I just read this order, a very, very recent order of the Supreme Court, where it expressed disbelief on the fact that if an accused person has not been arrested during the investigation and after the charge sheet is filed, how can that person, upon issuance of summons and that person appearing before the magistrate, be sent into custody? What happened was that this accused person in this particular matter, there was an allegation against him. The charge sheet was filed by the police, and after the magistrate court issued summons to this accused person, he went and applied for anticipatory bail. The High Court rejected the anticipatory bail, and against that order, the petitioner had come in a special leave petition before the Supreme Court of India. Now, this two-judge bench of the Supreme Court, in its order, has narrated the entire incident as it happened during the arguments, which, frankly, happens not too often. In this particular case, the judges said that this person has, come and sought in protection from arrest from us after the filing of the charge sheet, especially in a situation where once the charge sheet has been filed and prior to filing of the charge sheet during investigation, this person was never arrested by the police. How is it that at this stage, the police could arrest this person? And so the logical conclusion should be that instead of applying for anticipatory bail, the petitioner should be applying for regular bail before the magistrate, and the magistrate should be granting that regular bail to that accused person. To which the learned senior counsel for the petitioner explained to us that in the state of Uttar Pradesh, in which the matter is going on, there is a custom, the practice, that even if during investigation a person is not arrested, after filing of the charge sheet, when summons are issued to this accused person, he can, and especially in CBI cases or offences of a grave nature, the magistrate still does send that accused person into custody. And to avoid that, you have to apply for anticipatory bail. Now, when I read this, and they said that this seems so implausible to us, but in any case, we must pass some directions on this particular issue. And therefore, they issued notice and kept the matter on a future date for passing of orders or arguments or whatever's going to happen. What I find to be funny here is the fact that this kind of a thing has been going on for several years. In fact, I was also not privy to it for a long time. Quite a while back, this client came to me, said that he was not arrested during the investigation in his case in a matrimonial matter. Now the charge sheet has been filed, summons have been issued to him. What needs to be done? He says that my local lawyer in Noida court says that I must apply for quashing of this charge sheet and also then get a stay on arrest after the charge sheet has been filed. And I said, why not, at least right now, till we consider the rest of our options, why don't we just appear before the trial court, collect a copy of the charge sheet, and then see where it goes? And he says that there is an apprehension that I will be arrested. And I said it is completely implausible that once charge sheet is filed and during investigation you were not arrested, what is the need to have your custody right now? And the person says, no, this is what happens in the great state of Uttar Pradesh. So I confirmed it from a bunch of people, and I was told that in Noida, at least where this matter was situated, there is a small possibility that once this husband appears before the magistrate, pursuant to the summons that have been issued to him, pursuant to the filing of the charge sheet in the court, he can be sent into custody by the magistrate, which was so appalling to me. In any case, very reluctantly, I applied for anticipatory bail before the Court of Sessions in Noida court itself. We showed some good judgments by the Allahabad High Court and by the Supreme Court. And the Sessions Court judge was happy to grant anticipatory bail to this client, who then appeared before the magistrate free from the fear of any arrest or being sent into custody. Contrast that, the reason why I was so agitated while doing all of this is because in the city of New Delhi, at least, right, what we call the GNCTD, right, the National Capital Territory, there is a judgment of the Honorable Delhi High Court. I do not remember the year, but the name of the judgment is Court on its own motion versus CBI, in which the High Court took suo motu cognizance, which means on its own accord, without any petition, any application, any complaint, any writ petition, without anything. The court on its own motion took cognizance of a news article in which it was said, and correct me if I'm wrong, because this is a long time ago that I read the entire judgment. But from what I remember, the Delhi High Court said that this particular bench of the Delhi High Court said that I read this particular news article in which it was written that a Sessions Court judge reprimanded the police for not arresting an accused person after the charge sheet was filed and directed them to take this person into custody. And at that point of time, the court said that the conscience of the court is shook, because once the investigation is complete, there is no reason for a person who was at no prior point of time arrested to now be arrested. And that is why the court on its own accord issued directions specifically saying, and of course these directions are not to the police but to the magistrates in the entire city of New Delhi, that if an accused person has not been arrested by the police during investigation, after they have completed that investigation and are submitting the charge sheet now before the court, and the person now appears before the court pursuant to summons issued to it by this court, there is no reason for the magistrate to send this person into custody, no matter how grievous the offense. So now in Delhi, if I receive summons from a magistrate's court, no matter how grievous the offense, if I have not been arrested during the investigation, after filing of charge sheet, I do not need to now go to a sessions court and apply for anticipatory bail. I just need to instead take my regular one-page bail application before that magistrate court, and that is at least what I do, quote the judgment of court on its own motion versus CBI, and say that I am here pursuant to the summons issued by this court. I have not been arrested so far, and I am here before this court. Please grant me bail. And I have never ever, dozens upon dozens of times that I have done this, I have never ever faced any issue with the magistrate saying no, but I'm going to send you into custody. But this is something that in the great state of Uttar Pradesh, if you've not been arrested because you got anticipatory bail or stay on arrest or whatever it is, or the police did not arrest you at all for whatever reasons, after filing of the charge sheet, the magistrates apparently can send you into custody. And it is a good thing, of course, but the only question that begs to be still asked is, why so late? Why follow the Delhi High Court after almost several, I believe the judgment was passed somewhere around 2000, somewhere between 2008 and 2011. And, why the delay? Why so much trouble to accused persons across the great state of Uttar Pradesh and perhaps even other places in the country? Why do magistrates send a person into custody if they have not been arrested by the police during investigation? Hopefully, we will have pan-India directions by the Supreme Court in the near future, and people will be able to save lakhs and lakhs and lakhs of rupees. Each individual will be able to save lakhs of rupees, which they will not have to spend on lawyers now, trying to secure either anticipatory bail or approaching the High Court for quashing of the charge sheet and then trying to get stay on proceedings. I hope we have an end to it soon. End to this madness.